for joining us. This webinar hosted by KCAB Next. My name is Dana Kim, one of the co-chairs of the KCAB Next Steering Committee, and I'll giving a brief introduction to the webinar topic and the panelists and touch on what we do here at KCAB Next before handing over the mic to the moderator. As you all may know, KCAB Next is an initiative launched by KCAB to provide a platform for next generation arbitration lawyers in Korea to exchange ideas and grow their professional network. The KCAB Next Steering Committee, whose members are from a diverse range of background, aims to organize and host networking events, workshops, and webinars designed to enhance skills and facilitate collaboration between counsel and arbitrators closely involved in the Korean arbitration scene. This webinar is one such event, and we envision more in-person and online events to come in the near future. Now on to the topic of the webinar at hand. International construction disputes when different approaches to contractual interpretation collide. Disputes about the meaning of contractual clauses are a common issue on construction disputes. This is the case when dealing with bespoke contracts, but even when standard forms of contract can give rise to such issues. Different legal systems, common law and civil law system will have different ways of identifying what the terms mean. Interpreted in different ways in different jurisdictions. Also, we see a lot of issues and come across it quite often in the context of international construction disputes. So we are here today to discuss what issues should be checked by the parties who are about to commence proceedings in another legal system. We have a diverse range of leading arbitration practitioners joining us today from around the globe to discuss the topic at hand. The panelists are first, Yosuke Aso is joining us from Tokyo. He's a manager at Taisei Corporation and has been working for Taisei Corporation for more than 13 years, dealing with various legal issues relating to multiple construction projects. Yosuke has an MSc degree in construction law and dispute resolution from King's College London and was admitted as the fellow of the Chartered Institute of Arbitrators in 2019. Alien Fisher is joining us from Zurich. She is a partner at Lawson Legal, and she focuses on complex international construction and engineering cases, oil and gas dispute, sales, supply and distribution, contract, joint ventures, and post-M&A disputes. She has been praised by Lawson Legal as having excellent knowledge of the construction industry. Mino Han is a partner at Peter & Kim and is joining us from Seoul. He specializes in construction and engineering dispute and has also received an MSc degree for construction law and dispute resolution from King's College in London. Mino is dual qualified in Korea and also in England and Wales, and currently is the ICC YAP regional representative of Korea. Kara Howard is a partner at Vincent Mason and is joining us from Hong Kong. She has acted on arbitrations under HKIC, SIAC, ICC rules, and seated in Doha, Hong Kong, Singapore, South Korea, and Turkey. Kara is qualified in Hong Kong, England, Wales, and West Australia, and having spent over 10 years in Japan, speaks, reads, writes Japanese, and is specialized in construction engineering and infrastructural law. The panel will be moderated by In-hwa Kwon, who is a senior legal counsel at Korea Shipbuilding and Offshore Engineering. She is specialized in international commercial arbitration and is qualified as an attorney in Korea. She spent a few years in Vienna focusing on international arbitration before she joins Korea Shipping. Thank you once again for joining us for the webinar today. And now I will hand over to the moderator and the panelists.
Thank you, Dana, for the opening and the panel introduction. I also would like to thank KCAB and KCAB Next, as well as Zalafloyd Zatkovich and Pinson Masons for being our supporting law firms. I would just add a quick further introduction to the theme of our talk for our general understanding where we are going. As introduced, we would like to talk about the different approaches, in particular arising from how different civil law attorney perceives and reads legal text from a common law attorney and vice versa. This is anchored in how the philosophy of civil law and common law provides for a different burden or level of liability or responsibility in the outset. This is obviously an old topic, heavily discussed. Today, we would like to focus on the construction contracts and disputes and hear from the experts in the field about their recent related experience and thoughts, as well as how they would prevent or tackle any such challenges of having different or perhaps even contradicting approaches in a lively discussion manner. With this panel, we aim to first talk about the intricacies related to applicable law to the construction contracts and the challenges under a back-to-back contract. And lastly, if time permitting, we would like to also share tips on how to make an informed selection and effective preparation of an expert witness. Through the preparation calls, it became very clear to all of us that our panel has lots to share on the topic, and we will likely run short of time. So I might signal to each of you, our panelists, at times of our time running, and might ask you to cut it a bit shorter than planned. Last but not least, thank you all who joined us today. Now is the start of the day in Europe and close to the end of business hours in Asia. So we really appreciate all of you taking the time to hear our session. And I would monitor the Q&A section of the webinar platform here. We'll try to incorporate your question into our discussion if possible and related, or would keep them for the Q&A time, which we scheduled for at the end of our panel discussion for about 5 minutes. So please do feel free to leave your question at any time or comment, and we will do our best to get it covered. Without further ado, let me shoot the first question. And let us start from the scratch and talk about the importance of the applicable law. I'm going to direct this first to Eliane. In your experience, given the typical length and details of construction contract provisions for the operation of the contract, does the applicable law matter at all?
Thank you, Inva, and thank you for inviting me to speak at this webinar together with my very esteemed co-panelists. Looking at construction contracts and their length of sometimes up to 1,000, 1,500 pages, you'd be surprised because they govern so many questions in detail that you would think the applicable law doesn't actually have much of an importance anymore. But surprisingly enough, and adding to that also is that the typical actors, contracting parties in construction disputes, they don't just do one-off project and then have some other business. So they conclude these types of contracts on a regular basis. So you'd actually expect that most of what you need is in the contract, and it's quite surprising about how many things there can still be disputes about and what you then need to go to the applicable law for. So what I see most of the time is that interpretation is completely governed by the applicable law. So there are typically no provisions on how to interpret the contract, and we might have a chance to discuss this a bit later in the webinar. Interpretation can actually vary quite significantly depending on the applicable law. And then there are also quite a number of issues where the contract can be silent on, and which are issues that arise in almost every construction dispute. So concurrent delay is one of those issues. I've seen a bit more frequently provisions on that included in the contract, but there's still a lot of contracts where this is not addressed at all. So that means if the employer and the contractor, or the contractor and the subcontractor, both incur a delay at the same time, figuring out who is entitled to additional costs and who is entitled to liquidate the damages for this time, can be quite tricky, and not all applicable laws actually have a very good solution on that. Also on how to calculate profits for additional work, whether to include overheads, how much overheads can be included, and so on, is often not really specified in the contract as such, and is something that you then have to rely on the applicable law for.
Right, I think it was a very good introduction to what issues we might run into under different applicable laws. Thank you, Elian. Let me turn to Mino, continuing on with the applicable law issue. What other implications do the applicable law have other than obviously the selected law governing the contract?
To make today's webinar a bit more interesting, I'd like to say that I have a different view from what Eliana said. I agree that depending on the governing law, interpretation might change, application might change, but in fact, in practice, the distance between the common law world and the civil law world, at least in construction disputes, is closer than you think. It's not that far apart. And I want to give you one or two examples based on my experience. For instance, one might think common law is, we hate extrinsic evidence when interpreting a contract. It's all black letter, it's four corners of the contract, parallel evidence, blah, blah, blah. And then you think, but civil law is all about the real intent of the parties and what I had in mind and the subjective intent and so on. But if you go one step further or beneath the basic principles, you'll find that even under common law, for instance, you look at extrinsic evidence to understand the factual matrix of what happened when the parties signed the contract. In civil law, you actually ascertain the party's intent as expressed in the contract. You start with the text as well. It's not so much that you go into people's minds. It's looking at the text. So in practice, it's closer than you think, in my experience. The other example I wanted to share about that governing law is not everything is the background of the arbitrators, which is also based on my experience from last year. We thought, okay, this contract is governed under Korean law. Nice, we are Korean lawyers, and we have a better chance than the Swiss lawyers on the other side. It was not Eliana's law firm. But the tribunal, two tribunal members were English qualified, and one was from the US. And they took a very different approach, despite the governing law was Korean law. The outcome would have been commercially odd, to put it nicely, if you apply that guarantee provision only based on how it is written. And we said you need to look at various other circumstances and the whole structure of the contract. Nevertheless, the tribunal was much more conservative and didn't go into the factual matrix that we suggested. They applied the language of the contract as is, and which made me think maybe the governing law of the contract doesn't resolve everything. You need to consider who is applying that contract, which prism, which frame is applied, or is the contract viewed at. So two misperceptions about governing law that I wanted to share civil law and common law is closer than you think, and the governing law provision doesn't resolve everything.
Thank you, Mino. Given the stress made to, or non-stress made to the right selection of applicable law, or even the applying person arbitrator, which we'll come back to perhaps later in the point. I feel that we should hear from Yusuke now, who has been working as in-house for 13 years with Taisei Corporation. And I'm curious to know what considerations you give and what applicable law do you see or prefer most in your in-house experience from your company's position, and perhaps why?
Thank you very much for introduction, and thank you very much for all the people attending as well as panelists. Thank you. So I'd like to share my ideas, which governing laws or applicable laws I see most or I prefer most. As you may understand, that construction is something which we have to do that place. So we can't do completely all the steps from the outside of the country and bring everything to the country. It's impossible. So we have to be subject to certain law at the country where the project is located. And sometimes it is the case that the employer's requirements says that governing law is this, namely the country where the project is located. And we can't change that. And if we want to change that, you are disqualified, or we will not be given any chance to submit the tender or the quotation. So it is limited for the contractor to change the governing law of the project, especially under the main contract. So it quite depends where the project is located, but generally we have to accept the law of the country the project is located. But there are some chances for us to change the governing law, especially those are not relating to the construction project itself directly. For example, like a confidential agreement, something like that, or where the project is maybe done by only single contractor in the world. It's quite rare, I think, but where the contractor has a strong bargaining power, and if the employer is refused by the contractor, they have no alternatives, the contractor may have a chance to choose the governing law. Or sometimes the Japanese contractor may have a contract with Japanese employers executing in Southeast Asian countries, for example, like Vietnam, Malaysia, or somewhere like that. The employer may tend to choose the governing law as a Japanese law, despite the fact the project is located in Southeast Asia. But anyway, in a case where the governing law is a little bit flexible, we may propose Japanese law because we are a Japanese contractor and we know that law well. But there are some cases where the Japanese law may not be the choice for parties to a project. So in such case, for example, Japanese contractor, Taisei, and other foreign contractor or foreign supplier, we may go to other laws which may be considered as neutral or fair for the parties. Let's say like an Italian contractor and Japanese contractor, we generally go to Singapore or English law, so which would be fair, possibly, to the parties to the project. Yeah, but of course, it's a commercial matter, so we may have a chance to discuss depending on the bargaining power of the parties. Thank you.
Thank you, Yusuke. One very quick follow-up question here. If you have 100% bargaining power, let's say, would you actually prefer to select, well, let alone Japanese law here, a civil law or a common law as your governing law from how you see potential?
Or is it doesn't matter?
Maybe it doesn't matter, I think. Yeah, we are not strictly adhere to the principle. We are flexible to accept that. But of course, we need to care about the regulation, especially in relation to health and safety, for example. Yeah, but it is mandatory law and we cannot avoid the applicability of such law.
Right. Thank you. Thank you, Suke. Further, I want to catch up on what Mino was saying earlier, how a person with a certain legal background could really have an impact on how you read the legal text and how you would interpret under a certain governing law as well. So why don't we hear from our panelists' experience here? I will start with Kara, perhaps first. What aspects of contract interpretation under civil law come as a surprise to you or your client or to your co-counsel from common law background?
Thanks very much, Inwa, and thank you very much to KCAB and all the panelists today. It's nice to join with you. This is a really interesting question, and I thought about it for a little while. So what comes as a surprise for clients, I think, is that, first of all, there's a presumption that all the laws are exactly the same as their own. You always think that it's going to be the same. But I do agree with Mino that in some cases, civil and common law are actually gradually becoming closer and closer together, particularly in respects of term interpretation. I still think that they are different. And so that is a danger. And so having a presumption that the law is always the same is a very dangerous situation. And so if you're entering into $1 million contract on a construction project and you don't fully understand your rights and obligations under the law of the contract, it's akin to playing Russian roulette and betting on a card game where you don't actually know the rules of the card game. So it's quite dangerous. And we'll talk a bit later, I think, about the specific provisions that differ in construction contracts under civil and common law, such as force majeure and pay when paid provisions and time bars. But I thought it might help. I think I'm the only common law lawyer on the panel today. So I thought it might help to at least give a little bit of background as to the differences between the civil and the common law jurisdictions, just as basics. And I hope that I'm not feeding eggs. All right. So you all know that common law comes from Britain and it was passed down through the colonies who adopted common law. So that's Australia, New Zealand, Singapore, and Hong Kong, and other common law jurisdictions. The courts under common law are bound by judicial precedent, which is different to the civil law jurisdictions, which are more bound by codified laws. In the common law history, the approach for contracting parties was always that they were adversarial, they're in conflict, they were fighting or trying to obtain the best rights. And so there was less of a requirement to take into account the economic interests of the other party. And this is different to the civil law jurisdictions where there seems to be a presumption that there's going to be cooperation or spirit of fairness and good faith. And so this history, I think, is important to understand where the two jurisdictions are at now. That's not to say that there aren't provisions in common law that protect the other party. There's security of payment legislation and also that protects contractors. And we'll talk about that a bit more, I think. There's also consumer protection legislation, which is about protecting parties that have unequal bargaining positions. So in that sense, Mino's right, they are coming close together. There is a sense that you have to, in some cases, protect the other side. The other difference I think is worth noting is that in contracts, you must set out all of the rights and obligations of the parties in the contract itself, because there's not a lot of implied terms, it's not a lot of mandatory statutory obligations. And that differs with the civil law position where there is, conversely, quite a lot of mandatory obligations that you need to be aware of. And as a result, the contracts tend to be a lot shorter. When it comes to interpretation, and I think this is a key point, because it's something like that Mino said, I think, that is not included in the contract itself. And for common law jurisdictions, when it comes to interpretation, the judges and tribunals tend to construe contracts on an objective rather than a subjective basis. So in other words, the judges consider what a reasonable person in that party's position, possessing the requisite background and knowledge, might have understood the provision to mean. They don't look at what that actual party, himself or herself, thought the provision meant. They look at what an objective, reasonable person might have thought. And also importantly, under English law, the pre-contractual negotiations are generally inadmissible, and also parties' subjective declarations of intent are inadmissible. I think I should leave the civil law parts to the rest of the panelists to discuss in more detail, but I understand that there's a more interventionist approach under civil law where judges can more easily rectify contracts to align with what they perceive the subjective intentions of the parties might be. I think something that I just lastly touch on, and I think this is relevant to both common law contracts and also civil law contracts, is the importance of actually ensuring your draft of your contract is clear and use simple language in order to avoid uncertainties and ambiguities. And this is so important. So much of my work relates to contracts that are just not clearly drafted and could have been rectified at the time. And also, as far as possible, try and avoid that Russian roulette situation where you don't know the actual obligations you're entering into because you haven't checked the mandatory law of the jurisdiction you're contracting in. So always check before you sign. Thanks.
That is indeed a good advice. I would now turn to our civil law attorneys, Eliane and Mino. Let's first hear from Mino. Perhaps, do you have a similar experience? Was there any, let's say, a surprise from the common law co-counsel or opposing counsel under Korean law or any other civil law interpretation situation?
I wouldn't say that I have come across anyone who was shocked or surprised when seeing how Korean law is applied. But again, I've seen, say, misperceptions that Korean law / civil law is heavily governed by the principle of good faith. There is this panic attack of some English lawyer colleagues of the term good faith and civil law, and this is so unpredictable and so on. In practice, however, I don't know whether I'm here today to disagree with everything, but I would say good faith isn't as arbitrary and as discretionary as one might wrongly think. In reality, good faith is not so often, at least under Korean law, invoked to change the rights or obligations of a party. It's rarely so. And it is applied as per specific sub-principles. And one of them, for instance, is the principle of estoppel. So it's nothing so shocking. It's actually something that exists in the common law world as well. So again, coming back to your question, not that I've seen anyone being overly surprised by anything, but surprised by Korean law based on a misperception, I would say.
All right. Let's hear from Eliane. How's your experience in this regard? I reckon there is a connection problem.
Can you hear me now?
Eliane's side, or yeah. Mm-hmm.
Yeah. I agree with Mina that good faith is actually the last resort that you use only when you have no other means to argue the case, and that it is not often used to actually change obligations, but rather to tweak them in a certain way or another way. And also, I find that when you discuss and especially work with colleagues on diverse teams, so mixed between common law and civil law, I've often find that we actually reach the same result, as in the end result is often the same that we get to. It's just the ways to get there and the sort of methodology to apply can differ quite a lot. But sort of the outcome, how we will argue it in the end is actually quite similar. This is one point what Dakara mentioned, that in common law often, the subjective intent doesn't matter so much, although in civil law, the subjective intent is the starting point, and you first look what did the parties want when they agreed on a certain contract provision. It's actually when they are in dispute, it's usually because you cannot no longer establish what they wanted, and there was no common intent. So then the second step is also to resort to an objective interpretation, and it's exactly the same standard that is then used. What would reasonable parties in this situation have agreed upon? So it's sort of, the starting points are different, but in the end, they sort of converge to a very similar outcome.
Just on this, and to build on a question from the floor, from Nolan Lee, regarding common law background arbitrators using common law principles in contractual interpretation governed by civil law. What if they do it wrong, and what recourse do parties have against this, if any, if, for instance, a party is unhappy with the arbitrators doing so? I think that this is a great question. Number one, I think you need to nominate your arbitrator very well. That's the first thing you need to be conscious of. But what if the tribunal is already constituted and things are not going as you really wish it to be? I think as counsel, you need to be able to explain common law concepts in a civil law way, or civil law concepts in a common law way. It's two different languages, I would say. People communicate in one language and the other language. It's similar that people communicate in a way, in a sensical way, but the language might be a little bit different. So you need to be able to explain rescission by using the terms for termination, explain rejection of a performance by using terminology of repudiation, stuff like that. So as counsel, I think you need to be able to understand both systems and be able to translate to the two different languages, I would say.
Thank you. Thank you, Mino Penosandim, for catching the question. I see that there is one more question directed to you as well. Maybe you can answer it after this round. I would, before we move to the second chunk of the issues on back-to-back contract, I would just ask Kara and Yusuke, what are the neurologic issues in construction disputes that one should be watching out, in particular, given the different approaches under different laws? I will turn to Kara first.
Thanks, Inwa. There's so many provisions that you could raise and discuss in detail, but I think I'm just going to focus on two key provisions, and then also a procedural difference as well, if I may. So first of all, the two substantive provisions I was going to think about were force majeure and then notice provisions, time bar provisions. And so everybody knows that force majeure is intended to release the contractor from obligations to perform in circumstances of unforeseen natural occurring event, such as an earthquake or a flood, and which could not have reasonably been avoided. And civil law jurisdictions understand force majeure is codified. And so, for example, if you had a situation where with COVID-19, be likely to give contractors an excuse for late performance, and therefore a defense against the application of liquidated damages as a matter of law. And so that differs from the common law position, where force majeure is a creature of contract. It has to have a defined term, it has to have a provision in the contract, otherwise there's no entitlement to rely on force majeure. In the civil law jurisdictions, you do have the code, but you always have to be careful to check what your express provision might provide, because the express provision might change your codified entitlement. So you always check the provision before you enter into it in respect of force majeure. And also in relation to the current pandemic, we receive a lot of calls, a lot of emails in the last year in relation to entitlements to claim. And this is because COVID has impacted people's supply chains. It's impacted their access to labor and then their ability to meet their contractual obligations. And so many people are seeking to rely on these force majeure provisions. But if pandemic is not specified as a force majeure event in your common law construction contract, you'd have no entitlement. And so it leaves people in a very difficult position. Of course, there are potential grounds to rely on like change of law provisions and to a lesser extent, arguments based on frustration. But it's always best to have as broad defined force majeure provision as you can in the contract, subject always to what Yosko San was saying in respect of the fact that you can't actually negotiate a lot in some cases with your construction contracts. The second point I wanted to raise was about the notice provisions. And in English law, notice provisions are strictly enforced. So you have to comply with them. Whereas tribunals from civil law jurisdictions might not be quite the same. Many civil law tribunals might hold that time bar provisions are invalid, or maybe they forgive the lack of notice for a variety of grounds, maybe including good faith. For example, it had a case wherein the employer knew about and in fact caused the event, which was the subject of the claim. And so for that reason, the tribunal held that the lack of the notice provision was not a bar to entitlement. So this sort of situation is quite important. And it's quite, for this reason, it was quite typical to seek a common law trained arbitrator in circumstances where you're seeking to rely on notice provisions in a civil law contract. And so just like Mino-san was just a moment ago, I also last year had a case where I was working on claims under a contract governed by civil law, and we sought to appoint a common law trained arbitrator for this reason. And this is because we wanted black letter law interpretation of the notice provisions to preclude their entitlement. But one thing I want to add is that we also wanted a common law trained lawyer who was familiar with, experienced in, and had a good understanding of the civil law jurisdiction as well. And that's because we wanted this party nominated arbitrator to be able to speak and hold his own against the other two civil law trained arbitrators when they were raising points of civil law, so that he could disagree with their interpretation if necessary and the application of the governing law is necessary. So I think increasingly arbitrators are having a more broader spectrum of capabilities and understandings, and it's becoming important in arbitration. One civil law aspect, just quickly I'll touch on, is the difference in perception in relation to discovery. It's quite an expensive part of arbitration, and so it's something that needs to be worked out ahead of time before you get into the thick of it. And so for my team here, we seek as far as possible to agree the more neutral and kind of in between civil and common law jurisdictions approach under the International Bar Association rules for the rules for taking of evidence, the rules of conflict of interest and party representation. And this means that even if the parties themselves are coming from different backgrounds, or even if the governing law of the contract is a civil jurisdiction, governing law of the arbitration is civil jurisdiction or a common law jurisdiction, at least for that arbitration, you will have a clear understanding of your obligations and what is permitted and not permitted. And that in itself reduces the cost of the dispute overall, I think.
All right.
Out of curiosity,
Kara.
Kara, in the case you just mentioned, where the tribunal member you nominated was from a common law background, the contract was governed by civil law. Do you recall what happened with the notice provision? How did the tribunal apply and uphold it, if they did so?
In that situation, it was quite fact sensitive, and it was the case where the employer already knew about the circumstances. And in that case, because the employer knew and because the employer actually caused the situation, it was very difficult to rely on a common law interpretation that to enforce the notice provision. Yeah, so they upheld the civil law interpretation.
Interesting.
I guess we can all agree to what Kara was pointing out as things to watch out. I want to hear from Yusuke, from in-house counsel's position. What are the things that you watch out for and be careful about?
Thank you very much. Yeah, construction industry and construction projects invite a lot of disturbance and issues. So I'd like to highlight 4 issues. One is the DAB or DAB. Some of you may understand the FIDIC, so I'm assuming that FIDIC will be basically the contract today. So for example, the first is the DB or DAAB in 2017. So it is often the case that DAB or DAB is not established in a timely manner, or it may take so long to agree the DAB members. So it's very unfortunate that the parties failed to agree the dispute resolution process. As a result, the dispute may become bigger and bigger. So the second issue is the extent of discretion of parties to a project, especially in case of FIDIC, the engineer. So of course, the engineer is given certain extent of discretion, but it is very difficult to define the extent of discretion. So it is very difficult to make litigation or arbitration. So your judgment or consent or refusal is beyond your discretion. It's very difficult to prove. And also there is no contract between the contractor and the engineer. So from the contractor's perspective. So in such case, we try to share the profit or the basic understanding with the engineer. For example, the refusal of the refusal by the engineer, for example, like appointment of subcontractor, may have negative impact on the contractor, of course, but also it may cause delay, which would be the disadvantage to the employer. So if we could share the basic understanding that unreasonable judgment or excessive exercise of discretion might have negative impact on the project, we may act more reasonably, hopefully. And the third issue could be the management of cash flow. Construction industries has a lot of regulation with regard to the payments, which may be discussed later, but cash flow could be one of the most important issues in the construction industry. So, but where there is a claim or dispute, for example, like an instruction by the engineer or employer, but they say this is not a variation, this is a mere instruction. In such case, the contractor is quite difficult to argue that this is not within the scope of our contracts. So they can say, the contractor may say, but it may be exposed to the massive risk that it is in breach of the contract. So practically, it is quite often that the contractor does the work in accordance with such instruction, whether it constitutes a variation or not. But it means the contractor has to pay in advance, and they may be paid later. So this may cause negative impact on the cash flow of the contractor, and maybe the contractor may be put in a weaker position. And another issue could be COVID-19 issues. So it is already mentioned by Kara. So, but it could be quite difficult to estimate additional cost or time, how long you will need before submitting the tender or before concluding a contract. So it's quite difficult to estimate the impact. But however, we ask to the employer, it is also the case for the employer to understand the actual impact of the cost and their time. So it is a quite difficult matter to be decided. But even before we submit the tender and we ask the impact of COVID, how it can be dealt with under the contract, the employer may say, we cannot understand the impact, or we cannot answer fully your question, or at most they can say, we can discuss with that. So some standard forms may, like English forms, may provide the basis, but it is uncommon for us to have a detailed provision with regard to the treatment of COVID-19. So yeah, you need to understand, or you need to make a careful consideration in this regard. Thank you.
Thank you. Catching up on what Yusuke has mentioned as part of his bullet points on the issues to watch out, I wanted to chat more about management of cash flow. This may relate to our next issue on back-to-back contract, actually. I want to hear first about the role of back-to-back contracts that's quite heavily used in construction projects. Does this have any repercussions on construction disputes? I will turn to Mino for this, and perhaps also Ilian after
Yes,
him.
construction projects, I think, have three main features. One is it's about time, it's about space, and it's about multiple parties. And the third element, I think, goes very closely to back-to-back contracts. It's a mechanism to apportion and allocate risks, especially for parties in the middle, the sandwich parties, so that risk coming from above is flowing down below as it came down and is allocated and apportioned appropriately. In disputes, this back-to-back contracting doesn't resolve everything. For instance, if the main contract is, say, worth 100 million USD, and you have 10 subcontractors or 5 subcontractors, each contract value being 10 million, a tenth, say. And the delivery dates or the completion dates are not necessarily aligned, but they have a gap. There is a buffer, but still, if there is a delay by a subcontractor, the maximum amount of LDs that you can levy is, say, 1 million. It's 10% of the 10 million. Whereas in the main contract, which has a much higher LD cap, the main contractor may have to pay a lot more LDs to the employer, but can't recoup that from the subcontractor. So back-to-back contracting is a means. This is one of the tools to allocate risks, but you need to be careful to design the whole structure, and depending on which party you are, you may have to work out for other backup plans and mechanism to hedge your risks.
I'm turning to Ilian for the same question. How's your experience on this, or your view on this?
And so what Mina described is now a situation where the sort of you align the contract and the subcontract, but then you still end up with some risks, namely that maybe like the scope and the volume of the contract will be different, and therefore also the exposure to liquidated damages. But it goes even further when the two contracts are not aligned, either because the negotiators didn't think of it, or because it was a conscious choice. So as Yusuke said before, often if you negotiate and contract with state parties, you don't actually have a choice on what your applicable law is. So towards the employer, you just have to simply accept the FIDIC or their national law as applicable law. And still, as a contractor, you may then, with your subcontractor, where you are the one with the stronger negotiation power, typically, you may then want to impose your own law as applicable law underneath the contract. So you end up with two different applicable laws by choice, because you may have, I don't know, 10 subcontractors, which then all have the same applicable law, and you only have a difference towards the employer. And that can then lead to a lot of additional difficulties in time bar, notification provisions. Also, force majeure, as Kara said, can be quite differently interpreted depending on what wording, whether the word pandemic is now included in there or not. We will maybe have also the chance to talk of the strategic implications later on, because when you set up the proceedings, you have to consider very carefully on what information you disclose or not. I think that adds a completely additional layer to it.
It seems that we can agree that this back-to-back contract framework is a nice one. It can be a nice one and useful, but it's actually not perfect. And you as a contractor is, put in a difficult situation under this framework nonetheless. Let's take a step back, and I would like to ask Yusuke if you actually rely on back-to-back contract clause and like have it pay when paid for your subcontractors' payment requests, or do you rely on it at all?
I have to tell you, depending on the circumstance, in case of Japan, where the project is Japan or Japanese law is a governing law, we are generally not relying on, because we traditionally consider that the employer is reliant. They have a strong financial position, whereas there is a regulation with regard to the payment to the subcontractors. But in case of an international project, we do rely on pay when paid provisions or pay if paid provisions. Yeah, as I suggested, cash flow management is a matter which the contractor needs to pay attention duly. And of course, the payment terms are decided upon agreement by parties, let's say like employer and the contractor. And also contractor tries to maintain positive cash balances. But of course, there may be circumstances where the main contractor has to bear the risk of negative cash balance. So for example, in such case, we may analyze the financial state arrangement or the employer. In case of FIDIC, we may exercise rights under the FIDIC 2.4. And also we negotiate with the employer and subcontractor so that the payment and cash flows may be better for the contractor to the extent allowed under the law. And also we may try to negotiate with the employer. All sums will become payable before the completion or before the handover, so that we can exercise legal under statutory laws rights such as lien or something else. And also we have to care about the amount of interests, especially in case of where the inflation or interest rate is high. We generally try to match the currency between the payment from the employer and the payment to the subcontractor. But in case where the inflation rate is high, let's say like a Turkish, we may borrow the money from the bank locally, but in case we may bear very expensive rate of interest. So we have to consider these kind of issues. Yeah, and of course, the best scenario is the positive cash balance for the contractor, but it may not be working always. So we need to ensure so that the risk could be mitigated, even in the case of negative cash balance.
I see. I'm going to now turn to Kara here. We have also heard already from Mino and Eliane the difficulties of the rear projects. You have different LDs and you have different applicable law, different governing law applicable to all these different contracts and the chain of your contract and subcontractors deals through and through. What would be your view? Like, what should we look out for in a back-to-back contract, or how often do you utilize it?
Well, I think what Mino and Eliane were saying about the time and cost provisions needing to be back-to-back. So for delay LDs, for liabilities, as far as you possibly can, have them back-to-back. But I think I've got a couple of comments to add on to what Yusuke-san was saying and Eliane and Mino were saying. First, in relation to pay-on-pay provisions. and then the practical enforcement issues. And also, it might sound a bit trite, but a practical piece of advice to say that back-to-back does not mean cut and paste from the main contract. Okay, first on the pay when paid, it's important to remember that under most common law jurisdictions, security of payment legislation means that pay when paid or pay if paid provisions are unenforceable. So even if you include them in your contract, you cannot rely on them. And so jurisdictions where this is the case would be UK, or some states of Australia, Singapore, and in future, possibly in Hong Kong, but not yet. Another important aspect of the security for payment legislation is not just in protecting contractors or subcontractors from the pay when paid provisions, but it also protects them by entitling them to raise claims in adjudication against employers or subcontractors against contractors in a means that's swifter and cheaper. And in that way, they keep their cash flow. And as Joska said, cash flow is key in construction. And so if you have a contract that has a jurisdiction clause that permits this security payment legislation, you want to be aware of it, because there's usually brutal 28-day time limits for your submissions. And so you don't want to be caught by surprise. The second point was on enforcement. And so you may have dutifully lined up your cost and time obligations under the contracts, the main contract and subcontract, so that your back-to-back provisions all work really well. And you've won the award, you've done everything and ticked all the boxes, but you might not be able to enforce it in your jurisdiction where the subcontractor holds its assets. And in this case, any award is completely meaningless. And so, for example, in many of the Southeast Asian civil jurisdictions where I'm doing some work, these jurisdictions can be quite protectionist to look after their local subcontractors, and they might not enforce awards as you expect. And so it's important at the outset to also assess this enforcement risk in those jurisdictions when you're entering into the contracts, and ensure that you've got sufficient bonds, guarantees, etc. in place so you can neutralize that risk. And then again, ensure you're not left like holding the baby or having the gap in the liabilities between the main and the subcontract. And you might laugh, but on the practical issue of don't cut and paste, you would be astounded how often clients do simply cut and paste obligations from the main contract and put them in the subcontract. And they don't change internal clause referencing, appendix references, or even define terms. And because these clauses generally relate to time and cost matters, they're worth significant sums. And the effect of doing this is that the clause is either unenforceable entirely, or it can be subject to costly dispute just trying to work out what the meaning of the clause is, let alone determine entitlement. I had a contract that ineffectively cross-referred to the provision for LDs under a different contract that it wasn't part of its contract, and as a result, it is unable to claim any LDs. And so don't cut and paste. Please spend that extra hour checking all the cross-referencing and that defined terms work, and to save yourself a bit of anguish later on.
All right. I'm looking at the time. We are running very short with our time. I would suggest that I would give Mino and Eliane to comment further on this topic for 1 minute each, and we may need to close our session. If there is no further question coming into our chat, I will turn to Mino if you'd like to spend one minute.
It feels a little bit like Wismut rebuttal, Sorbottle. You were given a minute, but thank you, Inhua.
Exactly.
I think two things from Kara's presentation, so Kara's remarks, which I find one interesting and very important. The first one I found interesting is the other mechanisms whereby you fill in the gaps of risk management, and you mentioned bonds. Having in mind the whole risk profile and putting bonds in place that properly deal with your risks, I think it's very important. I agree with what Kara said. The second one, your anecdote or / episode regarding cut and paste, I fully agree. And parties may think that you have hedged your risk by exactly copying the exact same contract, and everything trickles down perfectly, but actually it's sometimes even worse than having a bespoke contract. So I fully agree with Kara's remark that you made.
Cheers. Eliane, you have 1 minute.
I'd like to just quickly pick up on one question which was raised in the Q&A regarding how you combine the 3 involved parties if you have back-to-back contracts into one arbitration. Of course, it's difficult to do because essentially we'll have to agree on if it's not already in the contract, which it usually isn't, to agree on a tripartite arbitration agreement. We are in a situation like that at the moment where it's possible that the parties would all agree, but we are representing the sandwich party in the middle, and strategically we are not so sure if this is actually what we want, because you're in a really difficult position, because you have to say towards the employer that, you know, nothing has happened, everything was fine, and then towards your subcontractor you have to say they did everything wrong. If you have to combine these 2 positions in one proceedings, it can be quite tricky. So if you don't combine them, of course, then you have to sort of do 2 arbitrations. If you lose towards your employer, you have to go back against your subcontractor. But then at least you can filter the amount of information that you want to disclose. And ideally, you could even have the subcontractor align and assist you in defending your case without formally being a party to the proceeding.
I know that everyone has to leave the office or start a day, but could I offer 1 minute to Yusuke to things that you watch out in the procedural stage? If you could wrap it in 1 minute. Let's say this is our last point of the session.
I'd like to leave it about the multi-party arbitration in relation to the procedural issues. So as Mino, I'll leave it give you answer to the question raised during the session. So multi-party arbitration could be one of the issues which would be most difficult, but worth being considered, especially where the contractor has a strong bargaining position and it tries to subcontract most of the portion or specific subcontract, specialist subcontractor, where it wants to ensure the back-to-back. Of course, it may be difficult because due to the consensual nature, which could be the cornerstone of the arbitration, but also practical issues and attitudes of parties. The contractor may, as a party in the middle, may wish to have multi-party arbitration, but the employer do not want to fight against 2 parties potentially, and also the disclosure related issues. Because the contractor employer does not want to disclose the documents to the subcontractor, and vice versa from the subcontractor to the employer. So there are some difficulties, but still it may help for the parties to ensure the back-to-back contract, especially for the party in the middle. So, and also there may be some differences between the jurisdiction, to what extent the consent is required. So yeah, in case you may wish to have, it may worth being considered, but this is a very difficult matter, so due consideration may be required. Thank you.
Thank you. It's unfortunate that we couldn't cover all the issues that we wanted to cover with our wonderful panelists today. I'm sorry. Perhaps, especially on the topic of selection and preparation of an expert witness, we might have another chance. In another webinar or seminar, we will get a chance to tackle that issue with our panelists all together again or with different members. But yes, I'm sorry we couldn't deliver that today, but I don't want to hold all of you too much longer. Thank you for all the panelists. Thank you for all the audience who participated our session today. I would kindly invite all of you to give a nice round of applause for our panelists here. And I will say goodbye.
Thank you. Thank you.
Thank you very much.
Thank you so much.
Thank
Inwai.
you all.
Bye.
Thank you, everyone.
Thank you for the questions from the floor. Thank you.
Thank you.
Bye.